After a 2-hour preliminary hearing Thursday under tight security, 34-year-old Jermaine Ruth was bound over to Ashtabula County Common Pleas Court on 2 counts of murder. With a large group in attendance, Ashtabula Municipal Court Judge Albert Camplease heard testimony from police, a U.S. Marshal, coroner's investigator, and an acquaintance of both Ruth and the murder victim, 25-year-old DeVonte X. McCurdy of Cleveland. McCurdy was shot as he drove down Fern Avenue and West 47th Street on July 25th. He drove a few blocks after being shot and collapsed. According to testimony, 11 shots were fired at the vehicle, 9 of which passed through and 2 of which lodged. One of those 2 that lodged is believed to have caused McCurdy's death. A wand was used to examine each person before entering the court. Courtroom doors were locked until just before the hearing. Among those offering security was Police Chief Robert Stell. Camplease also gave a warning.
You have been admitted to the room. You're aware that you've gone through a security screening. There is a level of decorum that is expected of each one of us as we proceed in this matter. Please, no photography, no recording. Stay in your seats. Comments, any disruptions will be appropriately addressed by the court and the security staff. So again, you're welcome to be here, but it is expected that you not do anything that would interfere with the course of the proceedings.
24-year-old Kelly Stillman of Ashtabula testified she knew both Ruth and McCurdy. She said Ruth made a living selling drugs. In fact, Ruth is also charged with drug trafficking. But his attorney, Jimmy Mack Jr. of Cleveland, waived the right to a preliminary hearing in that case. At the request of City Solicitor Michael Franklin, video cameras did not show those that were testifying in the case. Stillman also testified Ruth was upset because McCurdy stole 10 grams of cocaine from him. She also said she arrived at work and was talking to a friend, Amber Stevenson, when she heard Ruth walk into Stevenson's home and over the phone essentially admit to shooting McCurdy.
Who were you on the phone with?
Amber Stevenson.
Who's Amber Stevenson?
One of my best friends.
During that phone call with Amber Stevenson, could you hear anything going on at her house?
Well, it was just a normal conversation me and Amber had. And then all of a sudden I hear Jermaine come in her house and talk about...
Well, wait a minute. You heard a voice other than Amber's?
Yes.
And was it a male or female voice?
A man.
And did you recognize the man?
Yes.
And who was the man speaking?
Jermaine Ruth.
Right. Could you hear anything that Jermaine was saying?
Yes.
What did Jermaine say?
It was kind of shocking. I don't know exact words, but it was like I just shot at that bitch.
Objection, Your Honor. She doesn't know its exact words. I'm objecting.
She can give her best recollection, Your Honor.
I'll rule.
Your best recollection, ma'am.
It was I shot at that bitch ass nigga wrong, or I bodied that bitch ass nigga wrong. It was one of the
I
other.
bodied him?
Yeah.
What did you understand by the phrase body?
Killed.
Okay. And I'm sorry, Your Honor, I'm hearing some remarks from the audience. I'm wondering if we can have a cautionary instruction at this point.
Ladies and gentlemen, I did previously warn or admonish those present that they're to keep their comments to themselves, to not in any way or any fashion disrupt these proceedings. Any such disruption will result potentially in your removal from the courtroom. Please observe this admonishment. Thank you.
Officers testified security cameras at nearby Chick's Bar and Los Compadres both showed both men in the vicinity at the time of the shooting. Mack said nobody saw Ruth fighting with McCurdy, nobody saw Ruth with a gun, but City Solicitor Michael Franklin said there was sufficient evidence to bind Ruth over.
He was shot in the chest. It's apparent that the car he was riding in was basically shot to pieces with a high-powered rifle. The shell casings found at 47th and Fern are consistent with such a rifle. The location of the shell casings and the spent rounds in Los Compadres restaurant indicate that the shooter was on the street laying in wait for Mr. McCurdy when the shots were fired. We have testimony from a lay witness that Mr. Ruth had some issues with Mr. McCurdy over the alleged theft of some drugs. And from that same witness, we have an identification of Mr. Ruth's voice uttering in Amber Stevenson's home in an excited fashion minutes after the shooting that he had just either shot at or that he had killed Wonk, also known as Mr. That was Mr. McCurdy's street name or nickname. Under those circumstances, we believe we have shown that it is reasonable and probable to believe, and it is shown by substantial credible evidence, that Jermaine Ruth did, with prior calculation and design, purposefully cause the death of DeVonte McCurdy.
You want to believe in Stillman or not on this particular case, and I know it's probable cause, and that you are to weigh this favorably as far as the city or the state is concerned. I don't believe that they at least did not show that there is any prior calculation design, because one, you don't see on the night of the 24th of July or early morning of July the 25th, there is no argument, there is no evidence of any arguments between Mr. McCurdy and Mr. Ruth. So there's no motive, no intent there. Again, you don't even see Mr. McCurdy out in the parking lot when Mr. Ruth is out in the parking lot. The videos show that all they show is my guy leaving the parking lot. I mean, it's reasonable for anyone that knows that that's not his residence for him to be leaving the parking lot. And if that is a normal exit out of the parking lot, out onto the street, that's all that they have shown that happened on this particular night.
Now, in this case, I have a firearm that was located in the vehicle of the decedent. It was a semi-automatic firearm. From the testimony of Detective Felt, for that weapon to be fired, or were to have been fired, because of its very nature, because of its very function, there would have been a round in the chamber. There was no round found in the chamber, and therefore the court finds the greater weight, the greater evidence here is that this is, if there was in fact a self-defense issue here, it's, as Mr. Franklin notes, that is an affirmative defense. That's something that must be proven by defense. It's not something the state has to anticipate or disprove. So based on the evidence, I'm finding probable cause exists for both charges. I will bind both matters over to the county police court for further proceedings before the county's grand jury. The bond previously set will be